Good to see you, man.
Okay, it's 1:30 and I want to get started as quickly as possible because we have 1 hour and I think we have a fair amount of ground to cover. Why don't we just start with introductions around the table? Start with you.
Dennis Wheeler, Municipal Attorney.
Elby Green Johnson.
Dick Trey,
Tim Steele.
Jennifer Johnston.
Bill Evans, guests as well.
Dusty Menifee.
Will Hart.
Teresa Hillhouse, Employee Relations, Labor Relations Director.
Sarah Wright, Assistant Municipal Attorney, Civil Law.
Joelle Hall, Heidi Dragus.
Justin Roberts.
Jason Albert. Bill Sims.
Patrick O'Shea.
Dallas Smith.
Robert Jones.
Thank you. And Mr. Peterson is just joining us now. What I plan to do is, since I think the main focus of this meeting will be on Ms. Johnston's proposed ordinance and the matrix she has developed, give her the opportunity to explain what she sees as her position on this, give you a chance to weigh in on that. We've received a number of comments in the last few days since that's been out that Ms. Johnson will address. And hopefully, as we get to that, I want to reserve the last 15 minutes of this meeting, if Ms. Johnson's description goes that far, for the committee to make its, have some deliberation and make its recommendations for the assembly. We are on a bit of a kind of a constrained time schedule. August 18th is the date on which we have to either have AO 37 removed from the state's ballot. Otherwise, there's a potential that we can't do that. And there's only one meeting of the assembly before that date, which is August 5th. So our goal is to wrap up the labor subcommittee meeting today. There's a work session of the full assembly scheduled for this Friday. At what time is it?
I think it's
Noon to 1.
Noon to 1, thanks, good, somebody knows. And then hopefully these issues will be resolved at the assembly meeting next Tuesday. So with that, I'm going to turn it over to Ms. Johnson, and she can go over the ordinance.
So, just sort of to open up, and I've spent time with a lot of you, how I see this going forward is, if we're going to make any, if this ordinance, if my ordinance in some form passes or comes to a vote, it's going to need 8 votes to sustain a mayor's veto and to go forward. And I think I've said to a number of you, if we get to the point where it becomes sort of a public filibuster, it would be my intent to postpone the ordinance indefinitely and just forget the whole process. So the two things is we need 8 votes and folks need to be on board if it's going to make any progress at all. So I received comments from a number of you over the weekend from the matrix that we put out Friday. And Mr. Wheel and I will go through the matrix, and I will address some of the comments, and at least you'll know where I stand on the comments, so you'll know where my vote is if there were amendments. So if you're counting votes, this should be pretty transparent. So the first number 1 on this matrix, and there's some copies of the matrix. Hopefully everybody has a copy. And Dennis, why don't you just address
Sure.
number 1?
So number 1, one of the questions we had from APDA was, what does it do to holidays? Our response column on the far right indicates my thoughts on this. And on the holiday question, to the extent that the holidays are out of sync, I think it's the intention of the municipality to sync those up. So if the bargaining unit has a holiday that's not, quote unquote, the standardized holiday for the rest of the municipality, through negotiations, they'll need to adjust that to fit the rules. Conversely, if they don't have one, and I suppose there'd be some effort to sync that by giving that one to them. So that's the response to that one. There was a change to the use of definitions calling for direct law enforcement or direct fire emergency services. Those provisions were in AO 37 tied to managed competition. And since that section is not in this ordinance. There wasn't a need for those specific definitions, so that's why those are coming out. There was a question about why that's being done that way. So that's
So any questions as far as that? In other words, a lot of this was housekeeping. And, okay, number 2, there were some comments on that again this weekend. And that as far as the management rights. And in my draft legislation on page 6, A reads, without obligation to bargain unless otherwise subsequently agreed to by the municipality and specifically approved by the assembly. And there was a comment from, I think it was the police, I can't remember which union, suggested about without obligation to bargain. I would be fine with taking that out and just having that first sentence read, unless otherwise subsequently agreed to by the municipality and specifically approved by the assembly, it is the right of the municipality acting through its agencies too. So we would take out that first 5 words.
Mr. Wheeler?
Just to expand on that a little bit, IBEW letter of July 8th talked about some proposed language. We inserted this language to try to meet that request, but then the police union suggested maybe making a change to that. I would note that this section of management rights is tempered by other sections of the code, particularly subsection B, which follows on page 7, which says there's nothing incompatible with the maintenance of these rights and the collective bargaining process. So I think people need to focus that there's been code provisions that talk about this balance between management rights and the municipality's recognition that it wants to work in a cooperative environment with unions on a number of issues. So there's no change in B, with the exception of provision at line 14 that talks about if there's something that's contrary to law, of course we need to comply with the law. So just want to remind people that there is a balancing act already in code on that issue.
And there are things that we've been adding as discussions have been coming along. I added some discussions as far as safety at the very get-go in this discussion. So we're trying to meet a middle ground here, but that's where I'm at. I'm from there on, management rights is what's spelled out here. I take out those first 5 words, but I would still put in, and it was suggested by IBEW, and we'd use their language unless otherwise agreed, subsequently agreed. So any questions on that? Number 3, I'll have Dennis.
Sure. Again, with respect to management rights, the issue here is, I think, predominantly focused on how seniority plays a role in staffing and scheduling. And I think there's a desire by the sponsor, so it was present also to some degree in 37, to not eliminate seniority as a criteria necessarily, but to make it one of other factors that can be considered in scheduling and staffing. I included some possible examples in my response, which is to say that if there's special expertise or a chance to train up newer employees, or frankly to save some costs in terms of using most expensive employees, that there should be some flexibility to adjust to those factors rather than focusing on seniority only.
But it's still in terms of engagement in the bargaining process. We're not taking it off the table. Any questions? Okay, number 4. Yeah, go ahead.
So there was a concern by AMEA as to the makeup of the Employee Relations Board. You'll note in the response that prior to 2005, the code said that the members of the board had to be quote-unquote impartial, whatever that might mean to folks. It was changed in 2005 under the Vegas administration to focus on having people who had experience in management, people who had experience in labor, and then somebody from the general public. So, and at that time, the coalition supported the the ordinance. So we're not proposing any change to the board composition in this ordinance. And I'm not aware of any formal proceedings where someone alleged that the board was not impartial. I'm not aware of any efforts to change the code that was presented to the Assembly in that regard, other than what was in AO 37.
Okay, any questions on that? Okay, number 5, we've spent quite a bit of time on this, and I've spent time speaking with each of you on this. First, you go first, Dennis.
All right, number 5. All right, so we're talking about the definition, so we got to flip back a few pages in the ordinance to the definitional section. And supervisory, confidential employees are at page 3, supervisory employees, bottom of page 4, top of page 5. Predominantly, to sort of summarize at a high level, there's concern about the number of employees who might come out of any particular bargaining unit through these definitions. With respect to the confidential employees, let's focus on that one first. What we've added is the focus on duties that require direct or system access to confidential information. Okay, that's part 1. And that could affect a lot of people, because a lot of people have direct access to systems, right, that have this kind of information. But most importantly, then, is the focus on part 2. That access has to be focused on information which then contributes significantly to the deliberative process on labor, employee relations, benefits, payroll, or budgetary policy making. So simply because my office manager has access to PaymentNet or PeopleSoft, SAP, when that comes online, doesn't make them a confidential employee, right? Because my office manager doesn't involve himself in making policy or accessing documents to provide that level of development of policy. That's what we're trying to get to here. So we recognize that there's a lot of employees that have access. That doesn't by default make them a confidential employee. So I know Aitchison has suggested some language that would say,
Adding the word involved.
at line 15, it would say, whose duties require
What page are you on, Joe?
sorry, page 3.
Thank you.
The definition of confidential employee, line 15, would be revised to say, or whose duties require and involve direct and or system access.
And that made sense to me. I had no problem with it.
So that covers confidential users.
Yeah, confidential. And then,
So then supervisory. So we recognize that there are a lot of employees that have functions described in this definition to some degree. What I want to, I think I've done this before, is focus on the fact that when we talk about the payroll functions, we're not saying that just because you have the payroll functions, now all of a sudden you are a supervisor in this definition. It is just one of many indicia of what a supervisor does. So that's why it says some or all of the following functions in the critical line at page 5, line 1. If you have some or all of those functions.
and so, and my question, because I think that covers most all of with that municipal attorney's opinion, that covers most all the problems I've heard about the supervisory. And the only question I have is, it was brought up in the APD, that you have sergeants that are part of the hiring academy, or that do what you feel is hiring and firing. And my question is, are they actually the ones that ultimately hire and fire, or is it like, say, Dennis's office, where he has somebody that he wants to hire or fire? He ultimately doesn't make the decision, because executive, it's made at the mayor's office. Are those folks, they're part of the process, but the one that actually makes the decision of hiring and firing, is it the chief? Because that's where it differentiates between supervisory and non-supervisory. And because I really don't want to get to the point of listing out the employees that this doesn't cover, because you know that can get us all wrapped around an axle quickly.
That's great, Jack.
Thank you, Mr. Chairman. I just need some clarification on something I think that you said, and you used Dennis's office as an example. And I think that you said that if somebody that works for Dennis that's an executive, Dennis doesn't have the ability or whatever you want to call it to fire that person. It has to come from the mayor. Is that what you just said?
If it's an executive position, yes. So so could you answer that? Can you?
Dennis is not a supervisor.
Right, no, I mean, but we had this discussion with, I had this discussion with the police union, and they were bringing up these sergeants and their roles in the hiring academy. And so I just wanted to know if this ruling addresses that issue.
Right. If I may, through the chair. If our concern, our overreaching concern, is that by changing language, in this case, there's 2 sections that are added to it. It goes back to the intent, the desired intent of the change, the addition in language. There are a lot of positions that we could talk about that I think we would be left with questions, part of which you mentioned the academy. We have employees throughout various levels of the organizations, including even field training officers, who do make recommendations in terms of the ability to retain employees, potentially recommend discipline, if you will, in terms of poor scores. And so, and they approve time as well.
But are they recommendations to the chief?
They end up being recommendations through the chain of command, so they're involved in it. And so I think it goes back to the concern of what's the desire for the change, and that's what we should say in there. Because when it comes down to some or all of those functions, and I'll use myself as an example, I'm a patrol sergeant. I engage in about half of those things that are listed. When you add 2 additional factors, supervise and time and attendance, now you get me to, let's say there's 11 or 12 factors, I'm easily half of those. So is that some of the functions, and is that enough to where ultimately the ERB will say, the assembly took action to add 2 additional factors, and now Sergeant Aslan fits 2 additional factors, or if it's 1, whatever it is, the sum concerns us. So if the desire is to identify particular employees that we want to exclude, let's identify those folks rather than opening the can of a bunch of people that thus far the assembly, ERB hasn't considered, but now you've added some additional factors, now we open the door to consideration. I've been represented, historically we've always been represented, and I'll just use myself as an example, but there's a lot of people that are in that same feeling.
And then Dennis, can you give a municipal attorney's?
So the balance was between simply trying to list out who we have now and then having to come back again and again and change that, which is one mechanism, versus writing it in the way we have and allowing the ERB board to address that issue after both sides first attempt to work it out. If they can't work it out, to go to the ERB. The ERB looks at similar positions, it looks at its prior decisions, it looks at perhaps what other cities and state government do in classifying their employees, and then use that body of evidence, if you will, in their own experience and come to a decision. So we felt that was more practical and wouldn't require a revisit of this list over and over and over again.
In my mind, it's more like factors to consider are, as opposed to some. Then your some is kind of putting an arbitrary number on it, I believe.
Right. I don't think
And
so
if we just say these are some of the factors to consider, then it leaves the determination to the department.
I think something like that would be workable. I didn't change the old language, which is some or all. But we certainly could do that. It was never intended that if you hit 3, or you hit 5, you're a supervisor. That was never the intent.
Here's the question I would like answered. I don't want to put you on the spot too much, but anytime you change the language of the law, whoever's going to be interpreting it is going to presume that it was changed for some intention. Is there, adding these words to the definition of supervisor, is there anyone that the administration or Ms. Johnson actually has in mind that would change from a current supervisor to a non-supervisor? Or from a non-supervisor to a supervisor who's excluded from the bargaining unit?
Yeah, I imagine that question was asked last time around, and I don't recall whether,
Yeah.
I don't remember anybody or any position being identified in that fashion.
Is it, what I think probably would make a lot of people less anxious about this is if there was some kind of statement too that this definitional change is not intended to remove anyone who is currently in a bargaining unit to be non-represented.
Okay, my question to you with that, because we've gone around in circles on this, and my intent in legislation is not to have a legislation just for today. My intent is to have something that works with a changing workforce and changing technology. So by doing that, as the municipality goes forward and classifications change or employees changes, does that restrict? Because, you know, my standard example is, I always like to say, the permanent fund dividend program, which was highly labor intensive in the state. And now it's fully, or not fully, but it's automated, and it doesn't require the people and the classifications employees that it used to require. And I don't want to see that kind of system going forward.
Right, and I think, you know, if the intention is not to change anyone who's currently,
Right.
but to allow the flexibility in the future that if positions change,
Right.
or if job duties change, this is the standard that they will be evaluated upon. And I think that makes sense to me, that, you know, if for some reason right now sergeants are represented employees, they do some of these things, but currently under the definition they are in the bargaining unit. It is not our intention by changing these words to remove them from the bargaining unit. But in the future, should the department change dramatically the position of sergeant to add more of these things or to do something different, then they would be evaluated against this criteria as to whether they are appropriately within a bargaining unit. Does that make sense?
That does, I mean, that's kind of what we're trying to get at. But the language, I want to make sure the language does that.
Sure. Ms. Gray Jackson.
Thank you, Mr. Chairman. I really appreciate this conversation. And not to be rude, but first off, if it is the intent to get rid of, to make non-rep positions, to get rid of union positions, but I'll just put it out there. If it is the intent, that means, you know, nobody's going to admit it. Okay, number one. And number two, I really appreciate your proposed language to kind of emphasize that that's not the intent. But even that is really not going to make a difference. But thank you so much for offering those comments that I don't think Ms. Johnson agreed with. Thank you, Mr. Chair.
It's not that I didn't agree with it. I'm just, he's hitting what I'm trying to get. And if that's the language to do that, I'm very much in agreement with it.
Well, I'm glad to hear that, Ms. Johnson.
I've been fortunate enough to hear, you know, from Ms. Johnson and Mr. Wheeler as they work through this, and from members of labor about their concerns. And I think everybody's basically on the same page. It's just a matter of putting it in writing in a way that people aren't worried about unintended consequences.
Right.
And I think, and if Ms. Johnson is comfortable with it, and Mr. Wheeler, from the legal perspective, I think language just stating that this change is not intended to change the represented status of anyone currently in a union, that I hope that would be enough to satisfy the concerns that I've heard addressed on this particular topic.
You know, I guess on that point then, I'm wondering what's the point of adding the language that in the first place? I mean, how is the nature of a supervisory employee going to change so much that those words are going to give some sort of meaning to determining whether they should be in a bargaining unit? I would add the same with the confidential employees as well.
And that's, I guess, probably where we're going to disagree. Because I think, you know, there's a certain aspect of confidential employees, and I've had this happen where confidential employees have had access and modeling information on labor issues, you know, you're on both sides of the table. So I kind of wanted to have it as clean as possible, same as supervisory. And as you go forward and as the workforce becomes whatever, technology, with changing, as I keep saying, you know, the baby boomers are retiring, and we're going to have a different set of employees and workers. And so I'm just trying to get ready for that.
Mr. Aslan? Oh, sorry.
Just as a follow-up, I felt like with Mr. Wheeler's comment and the mention of Ms. Johnston that what I've heard is what we're not intending to do, and I think is kind of what Mr. Agus is trying to say is what are we intending to do by adding that language? What's the desired outcome?
So if I may, as I understand the desired outcome originally and as embodied in this particular draft was that it was, when we were working on implementing Kronos, for example, there was a recognition that there were all kinds of different ways that people were following the payroll requirements. And there was a concern and a recognition of a need to identify responsibility. So when you were looking at supervisors, we wanted to make sure that those supervisors clearly understood that part of being a supervisor was they had to pay attention to time and attendance far better than they had in the past. Because we've had a number of grievances where we've messed up payroll, frankly, to sort of oversimplify it, where we were not paying employees adequately or overpaying employees. And so we wanted to tighten up the chain of command when it comes to time and attendance. And Kronos sort of forces that to a great degree because it's very rigid in a lot of its applications. But we also wanted the supervisors to be on the hook, if you will, and be responsible for the outcome. So when we look at the definition of the supervisor employee, we say, well, yeah, you hire, you fire, you transfer, but you also need to be responsible for time and attendance. That's all it is.
And I'll say, as far as time and attendance, I've been aware of situations within the municipality that the directors are, it's not employee-based. I mean, there's been people at all levels that have done different things with time and attendance. Let's just put it that way. And so it's not, we're not picking on any certain faction within the municipality. But it is setting it up clearly that this is a responsibility.
Let's, in the interest of time, let's move on, and we may have more time to revisit some of these issues at the end.
Number 6, there was a communication gap between myself and the CFO. And so I'm going to have to, I mean, as I've said in the past verbally, this to me is pretty simple. You have a tax cap. You model, you have economic models on your tax cap. You have a range of what to expected revenues depending on, you know, it's not just depending on the budget, but you know that there's a range of, with a tax cap where you can come in over 5 years, and it's modeling. But as opposed to me saying that, the CFO will have it in writing, and we'll make sure that you get a comment, so you know how that modeling exists. But it's how we've been doing our 6-year financial plan for the last 6 years.
Mr. Chairman, one other comment on this particular section. Below the response column, there's a discussion about the timeline. There were some questions about the timeline from IEW. The goal there was to create more time between certain steps and the expiration of the contract, because I think it was understood that the current timelines in code weren't very realistic and we weren't meeting those despite best efforts. So the only purpose in this is simply just to start the process earlier with perhaps a better hope of getting it all done before the current contract expires.
Number 7, I don't think it's anybody's intent to not use FMCS. And they will, you know, and I think the less expensive, the better. This was more just sort of saying, if there's an expense, then we both come, you know, both municipality and the unions are responsible. So then everybody's got a vested interest in making it work and part of the process. But it's not excluding it, and it's not saying, no, we're going to go to a high-level mediator, or, you know, expensive mediator. I don't think that's ever the intent of this.
Mr. Train.
Well, we just add language to it, says the first option would be using
FMCS.
FMCS.
And
Okay.
and I asked about that. The only thing is I've been in touch, as I say, the administration does not support me in what I'm doing on this right now, but I do use them as a resource. And Nancy Ucera, who couldn't be here today, was saying that sometimes, we have to bring them up and house them from Seattle, so they're not necessarily cheap. So she was sort of saying that kind of limits it too, by putting them as the first options, and that was why.
Do we have any evidence of this? I'd like to see something that tells me this amount of money that we've spent on these, or many years, this amount of time we've had to use them. Because it seems like if we're not gonna pay the cost, and I wanna see evidence that, like Nancy's saying, that there's a cost to bring him up here to do it. Otherwise, I'll put it explicitly in there.
Mr. Earnhardt?
And I'm speaking for myself on the historical point of view. What happens is if you get to impasse, you want to resolve it, and there are many options on the table. FMCS is free, but there are the travel costs if they do come up here and don't have something scheduled. Typically, they may have mediators coming up. There's also a certain amount of, who's available. You got that one pick. The parties may want to get somebody locally that we can get next week or 2 weeks from now a lot quicker. They're local. Maybe we're paying an hourly rate, but we're not paying any travel costs involved in that, and it allows that flexibility. Because the other thing is, and you got to remember within the whole context of this, is every contract negotiation is different. Some of these contracts, even when we open a full contract, it's just a simple matter of 1 or 2 items we've got to come to an agreement on. Some, most recently IBW, 84 pages were rewritten, and that's a much more major undertaking. This allows the parties, the ERB ultimately can pick a fact finder or mediator for the parties. That's the ERB if the parties can't agree, but the parties can find a way that they can get it done more quickly, more efficiently, or more acceptable to both parties. We both agree we like this guy here. We can go to him, we'll take what he decides, or in the case of mediation, we're comfortable with him, we'll listen to him or her.
Melissa, are you representing yourself today or on the city?
I just wanted to make clear, I've come in here just as a concerned citizen. I'm not here by the administration. No one's paying me to be here, and I'm generally going to keep my mouth shut.
But I mean, that is helpful though, because you were asking for, and that was what Nancy was.
I just want to make sure we're not paying his dollar, because periodically he works for the city and he doesn't periodically work for the city.
It's probably much of a tempest in a teapot here about this issue. Would language that just says that absent agreement by the parties, FMCS is the source for mediation? It allows the parties to agree to something else if they want to, if it makes more sense. But if they can't agree, then it goes FMCS. Is that, Dennis, is that a problem?
There's no legal problem doing that. Whether that meets the goal of bonus, I'm not sure, because that makes FMCS the default. I don't know if that was the default, because then one side or the other can always disagree. So you always end up using FMCS. So I don't know if that was.
Because normally the ERB picks, if it goes to mediation, the ERB selects the mediator.
What it says right now is that if 90 days prior to expiration, the parties have not agreed to an agreement, the board shall select and assign a neutral mediator.
To my knowledge, that's never happened, but I believe there have been times when the board has said, we'll get 7 names from AAA, you guys will do the strike method, or have said, here's 3 local folks, you guys decide which of the, you strike 1 and you'll be left with a 3rd. So saying FMCS is the default kind of gets rid of the flexibility of the ERB to also be creative. But
We'll just deal with the business body.
Number 8, the idea of moving workplace morale and past practices. Workplace morale to me is subjective. Some people, you can have discontented employees in the best of situations, and you can have happy employees in the worst of situations. So that's a non-starter for me. And past practices, I've been told by many of you that when you start negotiation, you always start with a blank sheet of paper. And it's important to me that we do that. And this is just putting in the past practices are not part of the arbitration. I want things to be looked at this time in this section with this workforce and this. So this is a non-starter. So just so you know, you don't have my vote if these two things go back. Other than that.
Comments on it. While I appreciate Jennifer's position on this, and I understand the desire to start with a clean slate, and in a certain context, that's true in negotiations. You need to do. It's also true that the vast majority of what goes on in any collective bargaining relationship is not dictated by the specifics in the contract. It does involve huge amounts of past practice, and that's a good thing. For both sides, it's a good thing because you don't want to have everything written out specifically about how we're going to do this, how we're going to do that, down to the detail. And the only way you avoid doing that is to have past practices. And and throughout labor law, there has been a standard for how to evaluate those past practices. You can't have contracts, you can't have a past practice that's contrary to the contract language. But absent any language in the contract, arbitrators and others will give value to the past practice. And I think, while I like the concept of the clean slate, I think it would be problematic if you removed past practice as a factor. It's really just not done. And I think the city would lose as much as it would gain from that because there are a number of past practices that undoubtedly the city would like to protect. So I would just give that some thought, and we still have time before anybody votes on it, but I think it is an important issue. I agree with you on workplace morale. I think that's a little too much, but past practice I think should be moving on.
And that's it. That's the end of, those are comments that I received from the first introduction of the ordinance.
There's a bunch.
Oh, one more page, did I skip a page? That was Freudian.
Give a lot more fun than that.
Good. Nice try.
Moving right along. Number 9, this is Dennis's.
Yeah, so number 9, just real quickly, when I read through the code section, it occurred to me, and I don't know that this had been noticed before, but that subsection C that talks about subject by subject arbitration, the beginning of it just references A1 groups, right? Binding arbitration groups, police and fire, for example. And yet, it's my understanding that A2 and A3 unions also use the step-by-step arbitration. So in order to clean that up, so they're all 3 groups are using the same kind, I made some changes to effectuate that. That's the whole purpose of the changes there.
And we spent a lot of time on this because we ended up in our discussions getting confusing ourselves in reading this and making sure that we had the right intent.
Just from my knowledge, and I don't know this, historically with A2 and A3 units, does the city go to binding arbitrations with them? Or is that only when that strike is enjoined or something like that?
They go to arbitration, but not binding arbitration. So if there's an arbitrator's decision, then it goes to the assembly for 8 votes. That's what happened in the plumbers and pipe fitter situation, was an arbitration and went to the assembly for votes. So it's a final decision, but it's not binding because it's dependent on whether the assembly approves it or not.
But they go to interest arbitration over wages and benefits, and they do that whole process with A2 and A3 units?
Yes.
Okay. And when that's happened in the past, did they use the same criteria, the same division of issues that is used with the A1 units?
That's my understanding.
Are there any comments on that?
when we're looking at, first of all, interest arbitration is a defined term. It's used in other places in the ordinance as well. Interest arbitration is different than as compared to grievance arbitration, a little bit different. So to remove interest in there doesn't serve the purpose that you're trying to, and it is a defined term. It's something that we're all quite aware of what that is. There's a big concern here, and we have not had an opportunity to fully evaluate the ramifications here, but what you're talking about is it's my understanding this language goes back to when it was set, when the ordinance came into effect. I think the reason maybe it's not understood is that there's not institutional knowledge on the part of the municipality, and as Ms. Johnson said, you've talked it around and you had yourselves confused. It isn't used very often, but I think that we on this side do have a relatively clear understanding of how it's used. And so I would ask on this that we get some more time to evaluate when you delete an entire paragraph of language and start taking words here and there. There may be, again, unintended consequences. This actually brought out to me late last night, so I didn't get a chance to get a legal opinion from somebody who has been to binding interest arbitration to see how this deletion of the language will apply. It's an overall cautionary thing to say, if you sit in a room and you don't understand how it works, let's get with somebody who does before we start deleting blocks of language.
The interest arbitration is not defined in Title III anywhere. The deletion of the word interest is just cleanup. You could put it back in and there'd be no substantive change to any of this. So whether it's in or out, it's just cleanup. I didn't get any comments from Mr. Aitchison in regards to this section in his email over the weekend of this morning. So I understand.
As I said, that was something late last night where I want to illustrate that point because we discussed it and I wanted to make sure we're good. This is a cautionary thing, no acceptance on our part because we're not giving specifics is what I mostly want to point out.
And we do have the work session on Friday also, so you have a few more days if you have more time to study and there are more specifics you'd like to address, that'll be another opportunity.
And number 10 again, municipal attorney.
Sure. There's no change to current practice in terms of what happens when a contract expires. Therefore, there'd be no change to what happens when related LOAs or administrative letters related to that. They would expire by their own terms. Typically, they would expire with the contract. And if the parties have not reached an agreement by the expiration, then all of those agreements would be in effect. You wouldn't revert to some practice prior to the contract or prior to the letter of agreement. So there isn't intended to be any change in what happens if there's an expiration.
Is that all clear? And number 11, again, Dennis.
Yeah, so there's been this discussion about how CBAs get out of sync with the personnel rules, and sometimes the CBAs will contain exceptions to the personnel rules, which is all well and good. All we're doing here is making sure that if that's going to happen, that that's called out specifically to the Assembly, because they adopted the personnel rules by ordinance after public hearing. Presumably, they wanted those personnel rules to be followed and incorporated into the CBAs. If not, if there's good reason not to have the same rules apply to non-reps and execs as might apply to a particular bargaining unit, then that should be drawn and given to the attention of the Assembly, so the Assembly can say, yeah, we agree with that.
And to be clear, this isn't something that, if you have negotiating units and they come up with something that isn't in the personnel rules and is part of the negotiating table, they don't have to come to the Assembly pre-contract. It's when it comes to the Assembly as a contract, then it would just be a sidebar or an executive summary, so that we're aware of it, or whoever's on the Assembly is aware of it.
Yes, ma'am.
Joanne Inglis with AMEA. Who's responsible for submitting that to the Assembly?
I would say probably the
DER,
municipality.
yeah.
So who's responsible if they give misinformation?
Well, if they give misinformation, they're responsible for that information, and they need to be accurate about. You're talking about calling out the
So
changes.
are they going to a year later reject the contract because of some misinformation that the municipality gave the Assembly?
I mean, the question is whether there's a if there's a procedural defect in the assembly approval, and so a change that's not consistent with the personnel rules is discovered, oh, we missed this a year later. And so we've got to, I think the correction there is to notify the assembly. It's unlikely that the assembly would do anything other than A, admonish our department or whoever missed it, and B, make a decision about whether it's significant enough to ask the administration to open a discussion with the union. At that point, you're not going to just automatically invalidate it. What you're going to try to do is have a conversation with the union about what you should do about it. If it's not significant, it probably lives on to the next agreement. If it's something that needs to be changed, you might address it by a letter of agreement.
It's gonna be like a side letter.
Yes, Justin?
Through the chair, I have the same concern about what happens because I think when we're comparing a 50, 75-page collective bargaining agreement with the personnel rules, there are going to be a lot of variation. I mean, the personnel rules and the collective bargaining agreements cover the same subject matters almost all the way through: vacations, holidays, overtime, wages. Almost every sentence of a collective bargaining agreement is going to have some variation from the personnel rules, and so the summary is going to be very detailed, I would think. And I'm just wondering how this works with the municipality sending over a summary that could be hundreds of pages long, identifying all the variations, and if one gets missed, one that's substantial even, what happens a year later when somebody says, hey, this wasn't in that memorandum, therefore it should be voided or shouldn't apply or something along those lines. I think that's something we need to understand, what the consequence is of that memorandum that accompanies the collective bargaining agreement not containing that variation.
I think you've identified one of the reasons why there was an interest in trying to standardize language in the contracts and also revisiting the personnel rules to make sure that they coincide because of these issues about differences in language. Because as you know, in theory, the default is if a contract doesn't cover an issue, you look at the personnel rules. So there was this desire to sync up the contracts and adjust the personnel rules so that those were a lot closer than maybe they've become over the years.
Okay, if you can wrap up the last two items in the next minute, that'd be great.
Number 12 was a technical, and that was from, I think when the EMS was rolled into the fire system. And then number 13, yes.
Yes, they can appeal to Superior Court.
Yeah.
I'm sorry, I was not here earlier. I have a specific question about why Treasury staff is currently in Treasury. You know, when reorganizations occur, this happens when they're taken out of bargaining units. So I guess I'm trying to find out why the 6 to 8 people in Treasury are going to be taken out of the bargaining unit with this ordinance if it should take effect.
It's been a long-standing request of the Treasury Department and Finance to do that. And we went around and around on that with the AO 37 as to why they should be removed. And it was a policy/philosophical request by the administration at that time to change that. And I think when I talked to you, I had talked to you about how Treasury was all in back as 75. So there's been this, as you noted, back and forth. Sometimes they're all in, sometimes they're not.
So it's not because they're considered confidential employees or anything like that?
No, they're separately listed under those groups. And somewhat similar to some of the IT groups, my department, for example, they're called out separately as not being eligible for a collective bargaining.
What occurs if this takes effect to those employees when about pay issues and benefit issues?
I guess we'll have to work through those. I don't know.
Currently, some of them might be paid more than a non-represented employee, and they're saying from the same area because they have PIP or something of that nature. Currently, non-reps, although they've brought them closer, are a little bit less in pay. So this will have a financial impact on the employees.
Presuming that's the case, I think there's steps that we go through with ER, and there's some provisions in the personnel rules regarding pay changes as well. And I don't know the answer to talk to ER and finance about that.
And is this something, Dennis, that if need be, it would go to the Employee Relations Board? I mean, if you filed a complaint or?
I'm not sure what you mean
Oh,
by.
no, well, actually,
A
no,
questions.
no, just as far as whether they should be in or out of the union.
Well, the question, certainly with respect to whether somebody's confidential or whether it's supervisory, you can see where there can be some
Right.
disputes.
But this we've actually,
This one might be a little tougher. It might go to the ERB board, but I'm not sure what they would be able to do with it because frankly, if it says all municipal attorney staff are not eligible and they're part of my staff, they would be eligible. The same they would tribute as treasury positions.
Mr. Train, you had a question?
Jennifer, could you tell me, where is 13 located at, 80 or ADS? I don't find 195 in there.
13 is 190, should be at 195.
And it gets down to 185, 190, there's no 195.
It's not 190.
Maybe it's typo, I'm sorry. Yeah.
I just couldn't find 195.
Thank you.
With that, we only have a few minutes left. Felt that would take a long time. I would like to get a sense from the committee as to their positions as far as recommendations to the full assembly. I don't think I have to reiterate the options that are on the table, but if we could start with you, Mr. Traney, if you wouldn't mind.
There's substantial changes that need to be made. For example, I'm not going to accept on page 6 of 29A. I know Jennifer says 5 words, I want the whole thing gone. She didn't have that there in the original version. I don't see why it's there in the S version.
actually, that was word, the wording that was suggested by IBEW.
Well, I've not heard from IBEW on that, so. And there are some other things that I've got information from APDA that need to change.
So will it be fair to say you're requesting some changes maybe at the work session?
The work session. That would get the full body of the assembly.
Mr. Steele?
Yeah, my concern in general is that we could probably make it work. My concern, however, is that what we really need to keep in mind is that we're trying to rebuild trust. And we don't do that by placing fear in employees. So in my estimation, there's some things that we can work through and make some changes to. But the bottom line is our employees need to be happy with it. If we just go back to what it was, then they're happy with it. And we can work through the changes that need to be changed over time as the confidence builds. And that's my concern, is that you see out here, you see fear on people's mind as to what might be in the hearts of management as opposed to and their relationship with management and negotiation. So we talked about some serious things, and I liked some of the comments about why they were changed. But there's more we could do and make for greater acceptance.
So are you thinking that you just in the referendum?
I guess I would like to do that if we can work through something, if we can have a work session, if we can do something to where we can actually, again, go through these again and see if we can make a few changes. We identified some here today, I think, that would go a long ways towards doing that. So.
Mr. Johnson?
I've given my piece. We've just spent 40 minutes with mine.
Sure. And as far as I'm concerned, and I said it I met with a group of the various unions put together, and my position hasn't changed on that. I think it would be very beneficial for the city to be able to improve its labor relations. As I've said a number of times, there's nothing more expensive than having bad labor relations. I don't know, if I saw that this proposal was going to somehow have that, kumbaya moment and everybody was going to be jolly and happy if we passed this and it would be a positive move forward, I could possibly support it. At this point, I don't see that. I think there's a lot of big issues still that we're not together on. So at this point, I'm still open to what happens at the work session. But my view is to just let it go to the voters and let them decide. AO 37 is leave it on the ballot. We have a few 5 minutes left. If there are any comments from you, again, you'll have, come to the work session on Friday. The whole assembly will be there. You'll have another opportunity, but be glad to hear from you today as well. Sir.
Thank you, Mr. Chair. Well, obviously, I'd like to thank everybody for their time spent on this. From the beginning, Labor has endorsed this concept. We've wanted to sit down from the very beginning, 16 months ago, to have some input on this. That conduit was supposed to be through this process, and I really appreciate it. I think the majority of the crowds have expressed their concern to Mrs. Johnston. I don't know how effective that's been at this point. I know there are some days till Friday. We're still optimistic that we can maybe work through some of these issues. Mr. Chair, I'd like to thank you for 2 great points. One being the past practice, you're spot on with that, perfect. As well as a phrase to include, not to include current bargaining unit members. Those are spot on. Those are things we would have to have. Without some of those things and more, we could not and would not be willing to go forward with this. So I encourage things to keep continuing to move on through Friday. And thank you guys for your time.
All right. We're adjourned. Thank you very much.